And Papa's didn't think about that. Love technology. But like we say, thank you so much. We've got amazing Crystal Steward from the Family Solicitor Court. Amazing. You know, there are women out there standing in the corner of men to fighting for them and fighting for their rights. And I just cannot wait to hear her journey and how she's helping men out there or families in general. So I can't wait, which is coming soon. And first, I need to introduce my guest host. And when I say this, he just has the smile on his face. My King, Daniel. Daniel,
Hey,
how have you
Margaret, how you
been?
doing?
I'm very well. How are you?
I'm good. I'm good. I've been enjoying my Christmas. Spending time with the family, and now the new year, 2024, isn't it? Brand new show. Really looking forward to it. So, and yeah, it's something that we've been planning. Like I said, new speakers, new people, new topics as well. So. I think we're gonna share a little bit about that maybe later.
Yes, we will be sharing about that a little later. We have got some fantastic speakers and great topics all lined up for you. But today we are going to be focusing about family courts, the do's and don'ts, and how to navigate on that. Daniel, would you introduce our guest, please?
Yeah, so like to introduce Crystal from Starwater Solicitors. So she's a family solicitor and founder. Her primary focus is to empower clients with legal knowledge to enable them to make informed decisions. Crystal ensures that all clients are provided with at least 30 minutes free legal advice. She is 10 years qualified and Law Society Family Panel accredited, which shows particular expertise in the area of family law, exactly what we're interested in. Crystal practices solely as a family solicitor and has gained vast experience in all areas of family law. She's empathetic to the circumstances of all client cases, adopting a practical approach to problem solving to facilitate the best outcome for her clients and their children. But you're not just a lawyer, are you, Crystal?
No, I'm not, Daniel, because in life, everyone has something else that's their passion or their enthusiasm or something else they're good at. So I also sing jazz and I very much like music and live music and those sorts of things. So that's a passion of mine. And I think that, everyone has something other than their main career that they're good at or that they enjoy doing. So it's worth noting that.
You know what? I didn't actually know you sang jazz. And I know you had a business, didn't you? Don't you?
Yes. So I have separate business, which is a music entertainment company providing singers, bands, and musicians for weddings and corporate events called CR Vocals. But yes, jazz is the area that I sing. I actually sing myself. So that's my specialism.
Wow. So that's a really, two very different areas.
Yeah.
Two completely different areas. But I think nowadays, as I said, there's lots of hidden talents that people have. I can imagine yourself, Margaret, and you, Daniel, if I asked you something else you're good at, it wouldn't be just the fields that you're working in and we're talking about today. I'm sure you've got lots of other hidden talents.
Yeah.
I believe I have. And one of them is to talk.
A great one for this show then, Margaret. Perfect.
Perfect. Fantastic. That is amazing. You got two different business, but really different, aren't they? Daniel, you're singing jazz and everything. I'm looking forward to my tickets on the next concerts. All right.
Yeah, actually,
Crystal,
yeah.
yeah, definitely. We are going to be there. Crystal, tell us about yourself and what is your journey that actually brings you to, because the business as well, it is a solicitor law firm, is also yours. Tell us about your journey getting there.
Yes. So I didn't start off thinking I wanted to go into law. It started off when I undertook a law and politics degree and I specialised in family law. My background is I went to a performing arts school and college, so that's where the music comes in. But I thought if I become a singer, I should probably have a degree, so something behind me. And when I did the law and politics degree, it solidified my view that it would be really good to help people and to actually impact others' lives in a positive way. So I did some work experience at different types of law firms, and family law was the area I chose because of its diversity, the breadth of clients you can serve and assist in what is very emotionally driven, stressful situations. And so I worked at other law firms. And then 5 years ago, I thought, I can see the way things are working at other firms, but perhaps it doesn't serve clients in the way that they're telling me they want to be served. And what I mean by that is family law has often been quite restrictive in terms of flexibility and working around the client. So when I set up Stalwart Solicitors, the aim was to be different. And we do that by way of offering our clients lots of flexibility. We offer them evening and weekend appointments on request, 30 minutes free legal advice, and as well as virtual appointments, face-to-face appointments where the client lives or works. So we actually travel to meeting rooms in their locality so that they can attend the meeting either on their own or with a friend or family member. And in that way, it means that they can work around childcare commitments, working commitments, you know, and even on the more sensitive side, if they've been the victim of domestic abuse, it could actually place them at risk of harm if they were in the house with the perpetrator and they found out that they were receiving some legal advice. So all those considerations have been taken on board, as well as actually the clients have a meeting with the solicitor straight away. So they look on our website, you can have a look at the solicitor's calendar, book in a meeting, and it will be with me or one of the other solicitors, as opposed to having to speak to a paralegal or a secretary and then explain it again to a solicitor, which a lot of clients were telling me is quite stressful, particularly as you're telling a stranger for the first time some very intimate details and emotionally driven facts.
Wow, that is fantastic. So what I love about it is the easiest way they can contact you, because like you say, sometimes it's very stressful and it's very fearful, and to be able to see a solicitor straight away, I think that is absolutely amazing. That is really good. Daniel, did you wanted to say something?
Yeah, no, I was saying, I remember when we first met, that was one of the things that I really loved, your philosophy around, you know, serving the customer as well. So yeah, so but we're here to really talk about, you know, some few matters with regards to the challenges fathers face. Yeah. You know, we talk about single fathers on this talk show and the struggles they have, but often, you know, when they get into the court area, it's they're new, they don't know what to do. So I'm going to just ask you a question. You know, what are some of the most common challenges that fathers face during sort of child custody battles, and do you have any sort of practical advice for them?
Yes. So I'll start off by describing a little bit about the area of law we're talking about. So we're talking about child arrangements. So where there's a dispute as to where children live or time spent with the other parent. So I think what you're talking about, Daniel, is when perhaps a father is not being allowed access to see the child, or that's being restricted in a certain way. And it's very difficult because we know that fathers don't automatically have parental responsibility, but they can acquire that in several ways, from being named on the child's birth certificate, from marrying the child's mother, and they automatically get parental responsibility, or through a parental responsibility order. Now, because of that, sometimes if the mother hasn't placed the child's name on the father's name on the birth certificate, the father can often feel that they're not included in the child's life, and that can sometimes be used, unfortunately, as a means of trying to stop the father having contact. Now, the good news is that you can go to court and at the same time make both applications. So I think that's something really useful for our listeners to know, that if they don't have parental responsibility, if they are the biological father, they can still make an application to court at the same time as making an application to court for a child arrangements order to see that child. So you'd make a parental responsibility order application and a child arrangements order application. And the benefit of doing both at the same time is it saves you time and money, because they'll be listed at the same hearing date. And also it will achieve your objective of being more involved in the child's life, because we know parental responsibility gives you equal rights, duties and responsibilities in relation to the party's child, and the court takes a very positive view on parental responsibility, meaning that in 95% of cases or more, they're going to grant the father parental responsibility, and that's because they believe that a child should have both parents in their life and the value of both parents in a child's life. It would only be in extreme cases of criminal matters where there's been sexual violence, or that parent could place a child at risk of harm with evidence, would they say, well, actually it would probably be a negative thing for the child for that person to have more involvement. But most fathers are good fathers, and at the very least parental responsibility is something that they should have, and that the child should have the input of both parties to make important decisions. And when I say important decisions, I mean things like change of a child's surname, which school the child should go to, the religion they're brought up in. All those are really important decisions, consent to medical treatment, and both parents should have their say in those decisions. So I don't know if you have any questions for me on what I've just said.
But just with regards, you said there's two aspects. There's the parental responsibility, and what was the other aspect again?
Child arrangement. So actually the physical court order setting out days and times for you to see your child, that's legally binding. So when you go to court, it's taken the responsibility, the responsibility from the parents to make decisions together in terms of child arrangements. It's asking a judge, based on looking at what's in the child's best interest, to make a court order setting out set times and dates. And that's really good for the father, because it means the mother can't stop the contact because it's in the court order. It's all set out, the set days and times.
It's very interesting. So it's very interesting you say that, because you have all that arrangement being done in terms of like the father can go and visit the children or wherever the center they go, but sometimes the parent don't turn up, the woman doesn't turn up with the children. What happened to that? Yes, it sounds all good with the arrangements, but I've seen a lot of fathers that I've worked with, lots of time, what keeps coming time and time again, the woman doesn't turn up with the children.
Yes. Now, of course, if there's a court order in place, you can go back to court to enforce the order. And it's possible you can ask for a penal notice to be attached. A penal notice means the mother would be arrested if she didn't bring the child to the contact. Okay. Now, penal notices are usually attached in the circumstance where you have someone that has breached a court order. So you'd go back to court and say to the court, look, we've given the mother the benefit of the doubt. The order initially gives both parents the benefits of the doubt that the mother will make the child available, and then the father will return the child to the mother's care as set out in the order. However, as you said, sometimes one parent, won't bring the child to contact. And so there has to be a mechanism for the other parent to know that things are getting serious, and that the court makes orders for a reason. It's a waste of time and money for both parties and the court to keep on seeing the same families because one person is not respecting the court orders.
I hear that. I'm gonna come back to that. But does the fathers know that there is that penalized kind of court thing that they can go back time and time again to make sure that works? Because a lot of the fathers, sometimes what get them really frustrated is that they've gone to court so many times because the mother hasn't turned up, and that's not taking place. So
I think that's where it comes into it, the benefit of legal advice. Because myself, I've been a practitioner now. Well, it's now my 11th year. Hooray! Yeah, I'm on my 11th year now of practicing, and I still love it, which shows that, when you do a job you love, it's not a chore at all. It's something you enjoy, and you're growing with it, and you're helping more people. So it's actually really exciting. I think the job as a family practitioner is to think of ways to solve clients' problems. And what I mean by that is we do that through family law, but also practically. So, for example, what you're telling me, Margaret, is you're having these women that are going to court and saying they'll adhere to the order when it's being enforced and still breaching it. Now, if you're acting as a litigant in person, meaning you're not legally represented, I don't think necessarily you would know to ask for a penal notice. Because I don't think that's not naturally a step the court would take. For example, if I'm at court and I'm representing a father, and this is the course of events of what's happened in the past, either informally or since the court order was made, the mother is stopping the contact, I would say, a penal notice is a proportionate response. And in my submissions, I'd say to the judge, well, look, I know that normally Children Act orders don't have a penal notice attached. However, we have all this evidence that this family has come to the court 2 or 3 times since the final order was made because the mother's breached the order. She's not respecting the court order or understanding the seriousness of it, and therefore it would be proportionate to now take the next step, which would be a penal notice, because the family court in general doesn't act in the way that the criminal court does in terms of punishing people by arresting them or fining them. But they are things open to the family court when a person isn't able to adhere to the normal procedure or the normal orders that are made. And that's something that should be in place, I believe.
And just out of curiosity, how often does that happen, that, you know, someone doesn't adhere to, you know, what's set out in a court order?
I would say, if I'm honest with you, where the other side is legally represented, they will usually adhere to the order. And that's why ideally, if I'm on a case, it's ideal if the other side is legally represented. And that's because they know that the potential, how it will look at court if the person has to go back to court to enforce the order, because they know I'll do that. They know that my client will be advised by me that there are things that can be put in place. So therefore, if someone's legally represented, they're more likely to adhere to an order. If someone isn't, then they're not advised as to what the possible penalties could be. They probably think I can just get away with it. There's a lot of old wives' tales that perpetuate on the internet, for example, a lot of mothers believing women have all the rights and therefore they can do what they want, even if they have been through the court process. And therefore, it's those that are litigants in person, so not legally represented, that I've found in the past are more likely to not adhere to orders. And
the litigants in person, what percentage, you know, out of the cases that you come across, what percentage do you think are actually litigants in person?
Well, it's interesting you say that, because I feel like if the client has instructed me, it means that they usually have funds for legal representation. Now, the other side, it's sometimes an area that I find can be quite disgruntling. And what I mean by that is, for example, you may have a mother that perhaps financially cannot pay for legal services, but then may have alleged a domestic incident or something like that, to obtain public funding for those services. So, for example, most of the clients I have, the other side in children matters, the other side is legally represented, either because they're privately paying or they've alleged some aspect of domestic abuse and qualified for legal aid. Now, the issue I have is that I'm a person that I will act morally, and also I've come into this job to help people. So I don't like the fact, and this is me having male and female clients, that anyone can allege domestic abuse and potentially sometimes be successful in securing public funding off the back of that. And it can be that as proceedings go on, we're usually very successful at ousting someone who's made allegations that are not steeped in any merit. For example, in court, it might initially wash that you are saying the other side has been the perpetrator of domestic abuse, but then that has to be followed up by some evidence. So I want the listeners to feel comforted that even if domestic abuse is alleged against you, it's not a matter of the court saying, okay, she said you've been abusive, so we believe her. That needs to be followed up with evidence, and that's ascertained through the course of court proceedings. So what I mean by that is police disclosure. And police disclosure may be that she's called the police, but if you've never been cautioned or charged, that's not going to go against you to say that you've been the perpetrator of domestic abuse. Again, if she says, an incident took place, but the details of the incident are very vague and that it's not date specific. She didn't call any medical professionals in relation to herself or the party's child, or she hasn't informed any, domestic abuse organisations or children's services, or even if she has, that never went anywhere because there was no merit in that allegation to a third party going anywhere, that's not going to go against the client. So I would say that in terms of funding, most of my clients, the other side is legally represented, but I would say that the courts, as I've been practicing, 11 years ago to now, they have a very in-depth analysis process that they go through to determine whether someone's been the perpetrator of domestic abuse. Because I think, you know, some people are the perpetrators of domestic abuse, but it's important that that phrase is thrown around properly, backed with evidence. Otherwise, it completely dilutes the process, and those that are the real victims can fall through the net. You know, and that's the real difficulty. But the court has a proper process for that, and everything is based on evidence. So it's not just good enough. You know, sometimes it might be one person's version of events against the other one, but you know, usually you're not going to have a strong case unless you can link what you're saying to what you've done to as a result of that action.
Wow. I need to go back in terms of the financial side of it, because a lot of the fathers that I've worked with who are really, really struggling, one of them, it's definitely the finance, because they don't have the finance, so they have to kind of represent themselves.
Yeah.
So why is it then in some situation the woman could say abuse and everything, and then they can get legal aid and the man can't? So in what terms? It's going to be rather difficult for the men, you know, to represent themselves.
Yeah. So let's take a trip back down memory lane. In 2013, the Conservative government came into power and changed the legal aid provision. Legal aid was much more widely available in all types of family matters before 2013. And then the law changed, which meant that for men or women, you couldn't be eligible for legal aid unless you're on a low income or receipt of benefits and you didn't have a large amount of capital, as well as having evidence that you've been the victim of domestic abuse. Now, that evidence in some ways is quite broad, but specific. For example, the sorts of evidence you need to provide to a mother, or, you know, indeed, this is good for our listeners because they may have been the victim of domestic abuse and they can use this to qualify for legal aid themselves. It would
Sorry, just a quick one. Sorry. Is that the same for the father as well, or the man, if he then goes and says, actually, I've been domestically abused?
Yes. Anyone that's been the victim of domestic abuse and the other side has been the perpetrator can make an application for legal aid to be publicly funded. That means you wouldn't have to pay for your legal representation, or you may need to make a small contribution, but it would be the same. So in that way, it doesn't differentiate between the sex of a person, but it's just as to whether that person has the evidence. So the sorts of evidence that would be acceptable would be if the other side, so if the mother, for example, because we're targeting this towards our listeners who hopefully will use this advice to see whether they qualify for legal aid, if the mother has been cautioned or charged for a domestic abuse offence against them, if there's a domestic abuse prevention order against the mother's subject to bail conditions because of her behaviour. If the local authority can write a letter saying that they consider the mother a risk of harm to the party's child, or their GP can write a letter saying that they consider the client the victim of domestic abuse with the mother as the perpetrator and that they've referred them for support. Or if they've accessed support from a domestic abuse organisation and they can write a letter saying they've seen this person and, you know, in their view, they have been the victim of domestic abuse and the perpetrator has been the mother, or if they've stayed in a refuge of any sort. So and a letter from that refuge provider. So there is means upon which you can qualify for legal aid. But the difficulty is it's usually more, I would say, again, acting for men and women, that it's usually women that perhaps access the support more than men. So hopefully this is something that the men listening to this podcast can take away, that if they have been victim, you know, they need to reach out to an organisation who can really help them with the emotional support and practical support by virtue of what they've been through, but also can perhaps help them with qualifying for public funding as well. So
just a quick question as well, which came to mind. So the domestic abuse, under domestic abuse, would emotional abuse come under that, or?
Yes. So domestic abuse covers a full suite of domestic abuse and also coercive and controlling behaviour. So we're looking at physical abuse, verbal abuse, emotional abuse, psychological abuse, financial abuse, sexual abuse, coercive or controlling behaviour, or harassment. So all of those fall under domestic abuse, and the court has got better at understanding the facets, because I'd say even in cases where domestic abuse isn't a main issue, there's often some undercurrents of one of those forms of domestic abuse, whether that be coercive or controlling behavior or emotional abuse, that's kind of an undercurrent as to the proceedings. So it's really important the court is aware of that. And as part of that, CAFCAS, who are the court social workers and who are involved in the case from the onset, speak to the parents and sometimes speak to the children later on down the line in a child appropriate way, and is very much aware of the facets of how domestic abuse can manifest itself.
Because I don't know, and it'll be interesting to get your perspective on this. Is from my understanding is, you know, physical abuse will mainly happen from the guy to the female. Emotional abuse probably from the female to the male, just only because, you know, males are generally stronger than the females physically. So it's usually emotional abuse that comes. So yeah, do you see that as well?
Well, I would say that that you see more physical abuse that's reported. Women report physical abuse perpetrated by a male partner. However, there are these cases whereby, although women are weaker, you know, they can throw glasses at people, or, you know, scratch or prevent someone from leaving a room. There's lots of other things that go into it that maybe you wouldn't think of, and men are less likely to report those things because of fear of how that may look. I think emotional abuse is something that men can suffer from and women can suffer from. But I think, as you said, men would be more fearful of allegations of physical abuse just because of the difference in size. So they would probably have a perception that the police or a third party is more likely to believe the mother, because physically, how could, you know, she be able to do anything to him? Because sometimes, you know, I have my male clients that are saying that's not what happened at all. She attacked me. I didn't attack her at all. If anything, I was just trying to, you know, block her from hitting me more or something like that. So but then the story to the police is completely twisted around. So I identify what you're saying, Daniel, that the physicality issue is something that many men may fear when there's allegations of domestic abuse, just because someone may be more likely to believe the female partner just because they're smaller in stature, and their version of events. But what I would say is that most police forces now have separate domestic abuse teams. And I think it's really important that men don't feel that if they have been the victim of any form of domestic abuse, that they can't come forward. Because it's really important as well, I believe, for them to come forward, so that the narrative is changed in terms of what's actually going on behind closed doors. And that I always say in family law, there's a lot of myths that get put out of there. And as you said, Daniel, your immediate thought was, okay, domestic abuse, mainly women, you know, being the victims and men being the perpetrators. Okay, that's sometimes the case, but I think there's a lot more that goes on that's perhaps unreported. So I think that in order for society to kind of move ahead with what's going on in practice, it's important that men feel that they can access support and reach out, and that they will be supported.
I mean, it's interesting you're saying that, because in terms of the evidence, I just want to take you a little bit back a bit, because when you spoke about the lot of the evidence that has to be proven for any kind of domestic abuse, with men, it's going to be tough, the journey, because most of them don't want to open up to that journey, to go to the doctors, to go to any of those support places, which they do need it, for them just to access the legal aid to be able to represent themselves. Is there any way that the court can, the family court can look at that? That's one question. And another thing as well we touched, and this I've actually seen in the classroom. And one of the case was we were all just sitting there having a chat and everything. And when the guy just stood up and he said, "Look at me." And so we're not quite sure, but everybody, I'm the only female there. And I'm thinking, okay, first my initial thought, but I said, no. But then he asked the question again, "Look at me." And then obviously we all kind of stopped and we looked and everything. He said, and he was really tall. He said, "I'm tall. I'm a black belt karate. And my missus constantly hit me. And it got so bad at one time, okay, that I think he called the police. And guess what? He got arrested.
Yeah.
He got arrested and got locked up for a couple of, at least 24 hours before he was released. So again, how does, as a man, you can then go and have people to believe you? As much as he got all the bruises, not her, but they tend to believe her. So what are the changes that needs to be taking place so that if a man report a case to the police or anywhere else, that they can be believed and not having to go through that journey to prove so they can get the legal aid that they need, support they need?
Well, I think there needs to be a bit more of an openness in the community in terms of domestic abuse going both ways. And what I mean by that, I think we know that men's mental health is not necessarily in the best place in terms of support service or access to support services, and the stigma attached within the male community in terms of opening up emotionally and telling third parties that they may be struggling with their mental health. And domestic abuse, I think, in some way falls within that facet of something that's taboo that maybe a lot of men don't feel like they can open up and talk about amongst other men or other women that they know, because it's almost still in our society, men are thought to be, you know, got to be strong, you've got to be the provider, and the misconception that if you've been the victim of domestic abuse, it means you're weak in some way, or that that you must be lying. Why are you saying these things? Because it's not possible that your wife or your partner could do these things to you. Now, obviously, me being in the job I've been in, I've actually seen where the woman has been the perpetrator and there's been evidence, and so I know that it can work both ways, and I know that there is definitely a lot to be done so that there's more perhaps common thought process among society, and perhaps in advertising, even for domestic abuse organizations. I think it's great, and I know that a lot of them are tailored towards promoting that women have places to go for refuges and support helplines, and I don't think, of course, that should stop. But my point is, I think there needs to be more prevalent advertising and promotion of organizations that focus on wanting to draw men in, because I don't see that. I see a lot of women's organizations that are really successful, that lots of women are calling up and accessing that support, and that's excellent. But we need the equivalent provisions for men, because right now they're not out there, and where they're not out there and they're not visible, I think men still feel very awkward in going into that sphere and accessing that support.
I 100% agree with you on that, because for us, that's what made us to start the Father Talk Show, because simply the men felt there was no support there for them. So I agree with you. There has to be a lot more provision for men. They can walk in that and also feeling safe as they go into that. Can you just say there is a man that's going out there, a father who's going out there to represent themselves in court. Obviously, they didn't have the legal aid or the finance side of it. Is there any practical steps they can take to be able to support them? Can you just shed a light on that for us?
So if we think of the family courts as a process, so usually from initial application to a final order, it's going to probably take about a year. Okay, a year or just over a year. I'd say after COVID, the family courts, there is a big backlog. So depending on where you live, you may have your hearings closer together, or you may have to wait several months between hearings. There's usually a maximum of 4 hearings in the process. Now, the good news is the court is aware that some people can't afford legal representation. We have a cost of living crisis. Many people have to spend their funds on essential things, and provision of legal services for many is just not something that's affordable. They need to spend the money on food, roof over their head, bills. And so the court realizes that when you are acting on your own, they need to give you tailored instructions, so to speak, in terms of what's expected of you. So you can make your initial applications and things online, which I think is really good. It's progressive because it means you don't have to print out papers. Most people don't have printers at home. Anyway, so submitting an online application works really well for lots of people. And then the court will write to you and tell you, okay, we've received your application. The first hearing is going to be on this date, and it will tell you what you need to do in the order. So my top tip for all men out there is, if you're representing yourself, don't panic. The orders that you receive from the court will tell you exactly what's expected of you by which date. And you should always diarise the dates to make sure you get the documents in on time. So, for example, before a first hearing, they will say, CAFCAS, who are the court social workers, are going to call you to have a chat with you and mother so they can prepare an initial safeguarding letter. And what that is, it's a letter which sets out what the initial concerns are as they see it. So the concerns could be, any of them have raised any issues of domestic abuse, drug or alcohol misuse problems, or mental health issues. They would be the key issues that they would see as problematic, and that they would need a further role to be involved in the case to conduct a more detailed assessment of the family, including speaking to any children in a child-appropriate way. And they make an initial safeguarding letter, they prepare an initial safeguarding letter, which is sent to the court and the parties, setting out their recommendations as to how the case should be managed. And it will either say, look, this is a dispute between the parents as to where time spent with the non-resident parent. There aren't any prevalent safeguarding concerns. So whilst the court is going to have to make a decision based on what's in the children's best interests, we don't need to have any further involvement. Or conversely, they may say, well, one person has alleged these things. We don't know whether they have or have not taken place, or whether it's truthful, these allegations. But there will be some further role for us, because these allegations, if true, would be serious and would impact on where the child lives and time spent with the other parent. So it's really important that fathers out there engage with CAFCAS. Really important, top tip, because the court attaches a lot of weight to their reports, because they're expert social workers, really. They're court social workers, so they're very experienced in their field, and then they've moved to working to help the court in deciding children matters.
So basically, be as communicative as possible, speak with them constantly, just all of them,
be open, be truthful, make the appointments they set you to speak with them, and engage with them. And that would be my top tip, because if you're engaging with the professionals in the process, you stand the best chance of them identifying any concerns and also exploring concerns. Because often, you know, in the case where someone's alleged domestic abuse against a father, the father's concern is, firstly, when am I going to see my children? And also parental alienation, which is something we know, again, arguably, it's not something prevalent in every case, but it is the case where sometimes one parent can try and influence a child against the other parent to say, you know, your father doesn't love you or doesn't want to spend time with you. And that narrative to help support the other allegations they're making in terms of domestic abuse, all of which may be unfounded. So any concerns the father has, no question, is a silly question to CAFCAS, the court social workers. And importantly, it's essential, I would argue, that they get out their feelings and the issues that they have around the process, so that CAFCAS can identify where they may help or support. And what I mean is, because any issue that's raised by either parent will have to be investigated. So, for example, if the father was to say the mother suffers from mental health issues, initially there'd be a court direction set at the first hearing for a letter from the mother's GP setting out any past or continuous mental health issues or treatment. That would be the first step. And if that then came back saying that she does suffer from some concerns, details of what treatment she's receiving, and if she is receiving treatment, a letter from that provider, whether that be psychologist, psychiatrist, whether she's accessing counselling or other support, and any medication she's receiving. So the court will initially take on board the concerns of both parents and think about what court directions need to be made, so the court can determine whether that's a real concern or something that's not steeped in evidence that therefore they should disregard. Okay, so it's a process upon which we're trying to eliminate all of the things that could be a risk of harm, so that we can get to the main issue why we've come to court, which is deciding on a regular schedule of contact.
And just out of curiosity, whilst you're speaking, what came to me is are there any repercussions for individuals making false allegations. So, for example, if a mother claims the father did something and he didn't, and vice versa, what happens if that is found out to be true?
Well, it goes to the issue of credibility, and that's really important in family proceedings. If you lie to the court, then it's likely that anything else you say to the court is not going to be given as much weight or believed. And what I mean by that is, it's the classic case of the boy that cried wolf. If you start lying about very serious allegations of domestic abuse, and you say things happened, and it transpires that actually everything you were saying were complete lies, and you've sent the court on a wild goose chase to try and investigate these concerns, and they've come back that none of your concerns were valid, then that parent's wish to say, okay, the child's telling me that they don't want overnight contact because they feel that they're at risk with the father, that viewpoint is not going to be given as much weight by the court, because the court's going to say, well, if she's lied about that, she could be lying about that. We're going to need to use our own judgment, having spoken to the child, and perhaps, on the balance, the court's making decisions on the balance of probabilities. On the balance of probabilities, if she can lie about something as serious as that, she could probably lie to try and get the outcome she wants in another way by saying that the child is telling her these things. You see what I mean?
Yeah.
So they're not going to give her as much the benefit of the doubt.
But would if someone was to do that, are there any sort of punishments for that? Are there any, is it that the court, okay, they don't just give weight to it, or do they actually say, well, because this person has falsely alleged this, then we're going to fine them, or we're going to the court and send them to prison? I don't know. Is there anything?
So the family court, as I said, doesn't usually act in a penal way to send someone to prison or fine them. However, be careful what you wish for, because if there's a case where someone has alleged these things and started alienating the child as well, there's a possibility, and I have seen it, where the court has said, well, look, we see what's happening here. This parent's behaviour is actually damaging to the child. So although this was a case about the father's contact, we're going to order that the children live with the father, and that the mother only have supervised contact until she undertakes a parenting course or another course to learn about the implications and how that can affect children. So it can result in a complete change of residence.
How often does that happen, that you have that change where then the father would have custody to that children or to that daughter? How often does that happen? That's question one. But I'm going again in terms of visitation right, contacts right, because I have a father who's gone and got everything right, got solicitor and everything representing, and it was costing him a lot. And then after a week or two, the mother disappeared with the child, completely disappeared with the child. They cannot find the mother and the child. So when a situation like this happened, what happened to the father?
Right. So I'll answer your first question. So in terms of the issue of a change of residence, having practiced now for 11 years, I've seen it happen probably about 6 or 7 times, which I would say is quite a lot in terms of the amount of different types of areas of family law I cover. I don't just do children matters, I do divorce matters and protective orders if someone's at risk of harm. And it will be based on expert evidence. So again, looking back at what the professionals say, it's usually because CAFCASS has identified that the course of these proceedings, the full character of one of the parents, i.e. the mother, has shown that they have little insight, and actually their behaviour is emotionally damaging to the child themselves. And therefore that change of residence has to take place. So that's why engagement is so important, because at the end of the day, the proceedings, do last for a year or more, but you do get to the crux of it, the crux of the character of the parent, but also the crux in terms of any allegations. And that's really important because at the end of the day, the court's there to get to a solution based on evidence and based on having an in-depth analysis in terms of how the parents think. The detailed CAFCASS report is probably about 30 pages, having had many meetings with the parents, understanding their view process on the background of the relationship, what's happened in terms of contact, why it stopped, why they believe that contact should be a certain way going forward. Also speaking to the child in a neutral place, like at school or somewhere away from both parents, so they're not influenced by the parents and those sorts of things. So, you know, in extreme cases, a children's guardian can be appointed, which on top of Kafka's providing reports, is actually someone that makes the child a party to proceedings and is actually representing the child specifically, because it's almost the view that the parents can no longer act in a child-focused manner. So the children's guardian is going to write their own separate reports, having spoken to the child in depth before every hearing, and saying to the court, this is what the child's telling me because of this, this, and this reason. So it can get really serious. And those cases can go on for 1 or 2 years if you've got a children's guardian involved. And going back to your second question, you asked what will happen if a mother goes missing. So there's a separate court application you can apply for that. That would be a child abduction application. It's in the High Court. And again, we do help clients with these applications. That's where a parent goes missing with a child. Okay. If you believe a parent has threatened to remove the child permanently from your carer control or from the jurisdiction, it'd be a prohibited steps order. And you're saying that the child is at risk of harm, the risk of removal, because how it works is both parents with parental responsibility have to agree to a relocation or a planned holiday. That goes without saying. So if one parent goes away without telling the other one, you can make an application for a prohibited steps order. Or if they've already done that, it would be a High Court application for under child abduction legislation. And if that country is a Hague Convention country, it's easier to return the child. However, I've had a child returned from non-Hague Convention countries as well, but it's about the swiftness of making this application. So what I'd like to communicate to the fathers out there is, if a child is really being removed and you believe that they've been removed to another country, you know, there's definitely support in place. You can make emergency court applications. So it's about acting quickly in those situations.
And thanks for that. That was a really good explanation. So with regards to any sort of recent changes or sort of in law that have happened that perhaps could help fathers, or, you know, to help a more amicable situation come about, is there anything you could share light on?
So initially, I should say actually, that before you make a Children Act application, the court said that you need to, if possible, propose mediation, which is a form of dispute resolution. It's where an impartial third party assists you in resolving your children matters, but family mediation is not legally binding. So the idea would be that you try and narrow down the issues or resolve issues between you. You can't force someone to engage, though. So you can propose it, but you can't force them to engage, or there's no pressure on either party to agree something they're not happy with. If you can agree, you can go to a solicitor and we can draw up a consent order, which is sent to the court to be made legally binding, setting out the child arrangements you've agreed. But if you can't agree, that's fine, because you've ticked the box of trying to agree, and you can then go to court for a judge to decide, which is the child arrangements order application. So that's a good first step to consider. And also, a lot of the clients we take on board, the first step is that we write to the other side and say, look, we've been instructed, these are the child arrangements orders our client wants to put forward for this, this, and this reason. If you don't agree to them, then we're proposing mediation for the parties to try and narrow down or resolve the issues. And if you don't agree mediation, we tell them we're going to court. So the idea behind that is, again, a last attempt. Informally, they've tried to speak to the other side probably many times, but they probably haven't ever had a letter written from a professional outlining the merits of my client's case, the father's case, and that we're trying to resolve things if possible. But if not, we've got mechanisms in place telling them what we will do, which is we will go to court. And in some cases, that can be a successful first step that can actually cause the issue to de-escalate and actually be resolved. So it's worth trying that as a first step, knowing that you have the court process, because court should be a last option, should always be a last option, because it can be costly and time consuming, and also emotionally draining for anyone. So if you can try and resolve things outside of court, that is of course preferential, but the court system's there when parents can't agree. The court
so mediation is literally there well, it's a lot cheaper than going to court.
Yes.
You know, it's not as emotionally draining.
Yes.
Okay, all right. So suggest to do that first, if
Yes.
possible.
If possible, try to do that. Because even if you can't resolve everything, it could mean that there's less issues that the court has to determine, which can only be a good thing, because there's more things that are agreed between the parents.
Okay.
It's a great question for us. I think about a couple of years ago, kind of read an article, I think when I was just preparing to start this Father Talk Show thing. And one of them was if family, they're going for a divorce and everything, and it's automatically, I'm not sure if it's active, automatically it's 50% in terms of sharing the children where they stay. Literally, that's just put in place to say, okay, you're going to have so many days with the child, and you're going to have so many days with the child between the parents. Is that ever been put in place where it's that smooth transition in court? Because that was something they were going to, about 2 years ago, I can remember, they said that's what's going to happen. So that way, the father doesn't have to go throughout that length to prove whatever. So is that happening?
Actually, that's a really good question to ask. And actually, I'm really pleased you've raised that, because that's a positive development I've seen throughout my practice, that the court is very much open to making shared care orders, they call them, which is where the child will live with both parents. And we've been very successful in getting these orders. And actually, personally, if I'm honest, that's one of my favourite outcomes, whereby both parents can spend time with the children. Now, with home working now and flexible working, it even becomes a more realistic and option that can be undertaken, because the concerns that the court had previously was that often one parent worked very long hours and wouldn't be able to do the school runs, or, you know, the parents lived very far apart. In today's society, a lot of people have the option of working from home or flexible working where they can do the school runs. So the main concerns of the court, or considerations, would be if both parents live within, you know, a suitable proximity of the child's school and can do the school runs, there's nothing to prevent shared care. And in lots of my cases, that has been the outcome we've achieved, because often inadvertently parents do, when they separate, live within somewhat sensible distance between each other just because of the child arrangements issues. So that's something that already, you know, is a positive point. And secondly, now with, as I said, the flexible working options post-COVID, you know, that's a real solution to a problem that would mean that the child spends equal time with both parents. You don't have to worry as much about the specific drop-off points in terms of, you know, every other weekend having contact with the child, because it will just be split, you know, 1 week with one parent, 1 week with the other. And children adapt very quickly. The main concern of the court is what's in the child's best interest, and having a relationship with both parents is ideally what is in the child's best interest. And if the care can be split and both parents have flexible working to allow that to work, if it practically works, then the court will make an order.
That's fantastic. I'm really happy to hear that. We are coming up towards the end of the show. Can you give our viewers there, the fathers, at least 3 practical steps they can take if they're going through abuse at home behind closed door? And if it cannot be resolved, can they take the first step to see a family lawyer, solicitor? You know, the fathers, can they take that first step? You know, just say, okay, you mentioned something, because sometimes we work with people who are not IT illiterate, don't know how to use the computer, you know. So the process that you said, okay, you can go to, you know, you can go to the website, you can fill the form and everything. So we have sometimes parents who kind of do that. For parents like those, how could they get help, assistance? So
yes, so the first step I would say is try and keep a record of things that have happened. So ideally, when important issues have been raised, or if the police have been called, try and record those dates, because they will be useful if matters have to go to court, because the court will ask for a chronology of what's happened. And if you're date specific, then that shows some clarity in terms of the position you're putting forward in terms of when things have happened and what was the result of those things. So ideally, when communicating with the mother, if you can communicate by way of text message or email, that is better than telephone calls, ideally.
Just
And
because you
the
have a
next
written record.
Yes, so you've got your record.
Mhm.
Secondly, I would be saying, I know that my firm is quite unique. Not a lot of firms offer 30 minutes free legal advice. But if you can access that, that would be a good first step. For example, our firm, we send a complimentary email to clients after the call, just setting out what we discussed so they can have time to think about what their next steps could be. They could also potentially try and access some support from pro bono organizations. So there's sometimes, again, this is probably not ideal, but we're talking about a situation where they can't afford legal advice. So how would they go about practically filling in a form if perhaps they're not computer literate? I'd be saying there's law schools whereby the students who are training to be solicitors or barristers are supervised by a qualified solicitor in order to help clients undertake some work. So it could be filling in forms for them. So they'd have a meeting whereby the solicitor would be supervising the students who are training to be solicitors and barristers in completing information, such as information on the child arrangements order application, if they can't do so themselves by way of IT. So that would be something to consider. Okay, so firstly, I say keep a list of all your communications, ideally in writing. Secondly, I say access support. Some solicitors offer the 30 minutes free like we do, or pro bono organisations where you can go in and actually they'll physically fill out the form for you or assist you with some time. And I know resources are, smaller than they were, but there are still some organisations out there that can help you. And thirdly, I would say be transparent in the process. So once the process has started, I can't stress enough how, the truth will set you free, I'm afraid. And that's a good thing because I want the clients to tell me the truth so I can get them the best outcomes. But also if they're representing themselves, if they have a consistent story as to the narrative in this relationship or the abuse they've suffered, and they can back that up by date specific information, their version of events is likely to be seen as, strong. Okay. And by engaging with professionals, voicing your concerns, it will mean the process is a smoother process where the concerns you have about the mother are also explored, and that you get the best outcome for yourself and importantly, your children.
Oh, fantastic. Thank you. I want to ask one more question regarding about if they need any support where you've got solicitors, a family solicitor that's been trained to do that. Is that only can access it through pro bono, or can they kind of approach any college, universities, that kind of students like that there, so they can get, and is the training, is it free as well?
So I would say there's a website called LawWorks, LawWorks, and you can just literally search that on any internet provider, and LawWorks, it will come up with the option of searching different areas of law and pro bono organizations based near where you live.
Okay.
And they will come up and you will then contact them and they'll tell you about their availability, but that service is free. Okay,
that's free. That's what I wanted to hear.
Yes, and that's how you'd access that.
And if our viewers want to contact you, how would they do so?
Many ways. So go on our website. If they
visit one of your jazz performances, yeah?
Yeah, they can come into the audience and, during the interval, we can have a little chat about their family legal matters. That's also an option. Or they can they can contact me. I'm on LinkedIn and social media, so Crystal Stewart, find me on LinkedIn, or they can go on our website, Stalwart Solicitors, and actually book an appointment, a 30-minute free appointment for me to actually come and have a conversation with them. No obligations. I'm just going to be asking them some questions about the facts of their case and importantly empowering them with some legal knowledge, or they can call me. And my number
is that going to, will you say you're going to come to them, or is that through Zoom, the free 30 minutes, or is it
30 minutes is a telephone appointment that's booked in, and at a time of their choosing. So they choose the time and the date and I make myself available for them, and they can call us as well. So the number, I don't know if you want me to give you the number now on this slide.
Please do. Yeah.
0345 222 0452. So it's 0345 222 0452. Or they can email me, crystal@stalwartsolicitors.com, and I respond to all the emails and we'll book in an appointment. I would say, again, remember that at my firm, and I'm hoping that other professionals out there in this field, it's non-judgmental. So forget everything you think about lawyers. Family lawyers are slightly different in that, particularly the ethos I have at the firm and the rest of the solicitors I work with, clients are at the heart of what we do. We're non-judgmental. We're just after the details of your case so we can advise you as to the best way to get a positive outcome for you and your children.
Right, you're a unique breed, right?
Yes, I'm told I am a unique breed by the client. I like to think that we're very personable and we add a human touch because we are dealing with people's lives and it's a very sensitive area of law.
Thank you so much. Thank you. Thank you. I mean, definitely you are human. We can see that. Thank you so much. Thank you to all our listeners there to the Father Talk Show. We are coming to the end of it. And definitely I will be sending out again, Crystal, information with a new flyer, hopefully what we got here, so that way you can follow, you can phone and book for a free call. We just want to say we're here for the single fathers and we really want to support you as best as we can, and that's why the whole program is here as well. Okay, Daniel, I know you've also worked with single fathers. If they want to connect with you, they want to get in touch with you, how could they do that as well?
Yeah, sure. My email address is danield@clearthepath.co.uk, so they can just email me through them.
Yeah, and definitely if you've got any questions as well, please, you can contact us LinkedIn and also Facebook and Instagram. So we are quite there. So most of the time I do send some stuff out there. So please, it's been amazing speaking with you, and thank you so much to our guests.
Yeah,
Crystal,
thank you so much. I've learned
here.
so much, actually. It's really good.
I'm really pleased. I think you should be able to explain family law in a multitude of ways so that everyone understands. And I think that's what I'd say to the listeners as well. If, I'm speaking to you and you think, oh, that's gone over my head, I can explain it in many different ways. No question is a silly question because it is a very different area of law that most people have never thought about or know the details of.
Cool.
That's very true. That's cool. Thank you so much to all our viewers there. It's been absolutely amazing kind of having you here with us. Thank you. We look forward to next week, Saturday, to come and speak to you. Another thing I want to say to you, for the first time ever, we've got Valentine's Days. Father Talk Show presenting Valentine's Days, Kings in a Conversation. And I'm super excited that. So look at the flyers and the invite, and it's going to be the 14th of February, of course, and it's all men.
Well, what time? What time?
The time is going to be 3 o'clock. I know, I understand you. Yes, I know why. We'll come back to that later. But yes, definitely we are. I just think it's really amazing that we actually celebrate you guys on Valentine's Day. So do look at the flyer. So Kings in Conversation, Valentine's Day, Father Talk Show at 3 p.m. So we look forward to seeing you there as well. And also we are live next week with an amazing guest speaker, and we look forward to that. Crystal, thank you so much for coming in. We truly appreciate you, and thank you. And my friend Daniel, my king, Daniel.
Thank you, everyone, and thank you, Crystal.
Thank you so much, guys.
Thank you. Bye-bye, guys. Okay, we've come out from Facebook now. We're now live. Crystal, that was awesome.
You're still recording, though.
Now I'm recording. I'm just going to